Good morning, ladies and gentlemen. We are about to begin the function. I request you all to take your seats. And also a small, gentle reminder to keep your phones on the silent mode, please. Namaskar, ladies and gentlemen. On behalf of the Chief Justice of India and the judges of the Supreme Court, a very warm welcome to you all on this special occasion as we celebrate the 73rd anniversary of the establishment of the Supreme Court of India. On this occasion, we are honored by the august presence of the Chief Justice of the Supreme Court of Singapore, Honorable Mr. Justice Sundaresh Menon. We would like to welcome on the dais Honorable Dr. Justice Dhananjay Yashwant Chandrachud, Chief Justice of India, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India, Honorable Mr. Justice K.M. Joseph, Judge Supreme Court of India, and Honorable Mr. Justice Ajay Rastogi, Justice Supreme Court of India. May I request Honorable Mr. Justice Sanjay Kishan Kaul to give the welcome address.
Chief Justice of India, Dr. D.Y. Chandrachud, Chief Justice Singapore, Shri Sundaresh Menon, my brother Justice Joseph and brother Rastogi, judges of the Supreme Court, retired Chief Justices and judges of this court, Shri R. Venkatraman, Attorney General, judges of the Delhi High Court, Shri Tushar Mehta, Solicitor General, former judges, Shri Mishra, Chairman, Bar Council of India, Vikas Singh, President of Supreme Court Bar Association and President of the SCORA, members of the legal fraternity, ladies and gentlemen. As we celebrate the 73rd year of our establishment of the Supreme Court of India, it gives me great pleasure to welcome you all to the first edition of this annual lecture series. On behalf of our attendees and the Supreme Court, I would like to thank the Honorable Justice Sundaresh Menon, Chief Justice of the Supreme Court of Singapore, for agreeing to deliver the lecture. Under his leadership, the Supreme Court of Singapore has reaffirmed its position as an exemplar for judicial institutions across the world. It has stood as a monument to judicial integrity, impartiality, and independence, and it has played a critical role in the development of Singapore as the commercially sophisticated state that we recognize today. Chief Justice Menon is universally recognized as a brilliant and hands-on administrator. Singapore is now a renowned international commercial court, which was his brainchild. He leads the process of expanding Singapore's Legal Services Commission. He also has an eye towards the development of younger members of the bar, as he heads the Academy of Law, which works towards enhancing legal capabilities among the lawyers. He has previously occupied some of the most exalted positions and responsibilities in his legal career. He is the youngest Chief Justice in his country's history. He has previously served as the Attorney General, as the Deputy Chairman of the Singapore International Arbitration Centre, and as the Managing Partner of a leading global law firm. We are honored to have him here today, and we look forward to hearing and learning from his insights. The Indian legal system as we know it today has a long and contested history. However, the origins of the Supreme Court of India as the apex judicial institution in the country are easier to trace. The journey commenced in 1950 when the Supreme Court assumed its duties from the Federal Court of India, which at time was supervised by the Privy Council. At this point, the court conducted its sitting in Parliament House until it moved to its presence more iconic venue in 1958. From a bird's eye view, the building designs projects the scales of justice, perhaps revealing how even the most prosaic of matters must necessarily be located within its virtue. Since this period, Supreme Court has naturally found itself in the midst of India's intensely political atmosphere. After independence, the country was bourgeoning with different aspirations, particularly with respect to the areas of economic development and social reforms. The Indian Constitution granted Supreme Court a regnant and critical position in this process, to act as the apex arbiter of disputes, being limited only by boundaries it set upon itself and the confines of the Constitution itself. The present lecture series was conceived with the idea of to provide a degree of reflexivity in his endeavor, really an endeavor of our Chief Justice. The Supreme Court, as it must, faces an intense amount of scrutiny every day. It is rightly believed to be custodian of fundamental rights and the defender of individual freedoms. However, in this humdrum, perhaps it has become difficult to dispassionately evaluate the positions taken up by the court, particularly through social, historical, and comparative lens. Over the last 73 years, there have been many achievements and many challenges. At this present juncture, it was rightly felt that this would be an opportune time to take a stock of where we have reached and to chart a course for the future. We fervently hope that through this lecture series, with the aid of distinguished speakers such as Chief Justice Menon, we can contribute to this process of strengthening the institution that we so revere. Chief Justice Menon today will speak about the role of judiciary in a changing world. As a prelude to his speech, I would like to take this opportunity to elaborate on my aspirations for this lecture series and what we can expect from it as it develops further in the future. As I hinted earlier, the Supreme Court has always been influenced by the dynamics of contemporary political forces, the dominant economic realities, and the landmark social events. As Henry Sheen said, every age has its problems, by solving which humanity is helped forward. The court thus has to reorient itself sometimes radically in the face of different challenges. Immediately after independence, the court's concern was to play a supporting role in the institution building process, cautiously developing its own sphere of influence. Later, during the period of economic instability, the court took a more active role in questions relating to the economic order, such as through the decision in the bank nationalization case. Post the emergency came a period where Supreme Court took upon the task of administrative review in a more serious way and started developing rigorous due process jurisprudence through a case including Maneka Gandhi. Then came the advent of public interest litigation, which has become synonymous with the right-based litigation in India today. We are thus left to contemplate what our present generation great challenge could be. To contrast the contemporary modern world from its predecessor, one can certainly point towards forces such as globalization and multiculturalism that are rapidly reconstituting the world as we know it. Judicial institution must, like every other social entity, cannot claim to be immune from this process or remain as mute spectators. Domestic laws are increasingly affected by happenings in other parts of the world, and vice versa. Progressive judicial decisions in other countries can have a reasoning effect in other jurisdictions, forcing an examination of one's own rules and methods. On the flip side, there are issues of transnational importance that can simultaneously invoke the attention of multiple jurisdictions, such as cyber security, global warming, and terrorism. Thus, since the nature of challenge is global, our response cannot afford to be local. Justice Oliver Wendell Holmes famously remarked that life of the law has not been logic, it has been experience. I thus ask, what better source of experience can there be than the lives of others? As the world has gotten closer, there is a greater overlap in our social challenges. Questions of balancing economic development vis-a-vis preserving labor rights, interpreting our laws in a ways that can protect our most marginalized communities, enabling the state's desire for collective security while preventing individual freedoms from being trampled upon. These are a common set of questions that every society across the world must answer. We do not have to follow the dominant mode of thought, but we can only develop our unique positions once we know what has been tried, what has succeeded, and what has failed. Although we are bound exclusively by our own laws, us judges increasingly cite foreign judgments, not as precedent, but as reflections of how other people around the world have interpreted these common social questions. In Justice K. Puttaswamy's case, we looked at the experience of countries such as US, UK, South Africa, and Israel, and the realms of privacy and data protection laws, as India did not have such a comprehensive regime. Similarly, in the interregnum, as our country develops its own cross-border insolvency law framework, India tribunals have been adopting the best practices from countries such as Singapore and Canada. In this context, I hope this lecture series will initiate a more systematic and a more rigorous process of developing our own jurisprudence through a comparative legal method. Ultimately, the Indian Supreme Court is part of a larger global fabric, that is, the order underpinned by the rule of law. Rule of law stands as the antinomy of capriciousness, despotism, arbitrariness, and tyranny, and can thus be considered as truly international and intrinsic human value. As defenders of this idea, courts across the world converse in a shared language of liberty, democracy, and equality. As we continue working towards strengthening these relationships, I would like to leave you all with a quote from Dr. Babasaheb Ambedkar. The Constitution is not a mere lawyer's document. It is a vehicle of life, and it is a spirit is always the spirit of age. Thank you, and Jai Hind.
Thank you, sir. May I now request Dr. Justice Dhananjay Yashwant Chandrachud, Honorable Chief Justice of India, to address the audience.
Honorable Justice Sundaresh Menon, Chief Justice of the Supreme Court of Singapore, my distinguished colleagues in the Supreme Court of India, distinguished former Chief Justices of India, former judges of the Supreme Court, we are deeply beholden to you for your presence this morning. Judges of the Delhi High Court, the Learned Attorney General for India, Mr. R. Venkatramani, Learned Solicitor General Mr. Tushar Mehta, Mr. Vikas Singh, President of the SCBA, Mr. Manoj Mishra, President of the SCORA, Mr. Manan Kumar Mishraji, Chairperson of the Bar Council of India, distinguished guests, members of the bar, ladies and gentlemen. I join my colleague Justice Sanjay Kishan Kaul and all other colleagues in welcoming Chief Justice Sundaresh Menon. I know that all of you are eagerly awaiting to hear Chief Justice Sundaresh Menon's lecture, and so am I. We have gathered today to commemorate the 73rd anniversary of the establishment of the Supreme Court of India. The Supreme Court came into being on 28 January 1950, 2 days after India adopted its constitution and became an independent sovereign republic. From this year, we will be commemorating the first sitting of the Supreme Court each year by organizing the Supreme Court of India annual lecture. It is an honor to have Chief Justice Menon deliver the first annual lecture on the theme, the role of the judiciary in a changing world. We have, as our distinguished guest today, a jurist extraordinary. He has the unique distinction of having served as both the Attorney General and now as the Chief Justice of Singapore. He is truly in the tradition of scholar judges. Just yesterday, he presented to me one of the first few copies of his book titled Transnational Commercial Disputes in an Age of Anti-Globalism and Pandemic, which he has co-authored with a distinguished scholar, Anselmo Reyes. So we couldn't have had a better speaker, judge, and scholar than to begin this lecture series this morning. The Federal Court, created under the Government of India Act 1935, was the predecessor to the Supreme Court. But its jurisdiction was limited to adjudicating disputes between provinces and federal states and hearing appeals against the High Court decisions. In contrast, the Supreme Court's jurisdiction not only extends to hearing criminal and civil appeals, but also extends to the enforcement of fundamental rights and disputes involving the states of the Indian Federation. In addition, our court can advise the President on important questions of law. The Constitution has envisaged a unified and integrated judiciary with the Supreme Court of India at its apex. The Supreme Court serves the world's most populous democracy and is in true aspects a people's court because it's a collective heritage of the people of India. The Supreme Court's opening session was held on 28 January 1950 in the Chamber of Princes in the Parliament building, where the Federal Court sat for several years. The inaugural proceedings were marked by an air of solemnity and simplicity. At its inception, the court had a sanctioned strength of 8 judges, but the court started functioning with an occupied strength of 6 judges. During the inaugural session, all 6 judges of the Supreme Court, including Chief Justice Harilal Kania, took their seats on the dais. In attendance were the Chief Justices of the High Courts, the Prime Minister, other ministers, ambassadors, and diplomatic representatives of foreign states, a large number of senior and other advocates of the court, and other distinguished visitors graced the occasion. In his address, Chief Justice Kania prophesied that the court will play a great part in the building up of the nation. Chief Justice Kania's words were prescient. He said, and I quote him, "India has chosen to have a written constitution, and the duty of interpreting that constitution with an enlightened liberality falls on the Supreme Court. The Supreme Court will declare and interpret the law of the land, and with the high traditions behind the judiciary of this country, we are convinced that the work will be done in no spirit of formal or barren legalism. It will be our endeavor to interpret the Constitution not as a rigid body, but as a living organization, having within itself the force and power of self-government." Those were the words which have animated successive generations of judges, including so many distinguished amongst them who are present with us today. In its first year itself, the Supreme Court heard a number of cases related to matters of fundamental rights, including the freedom of speech and equality. As the court began its functioning, several doyens of Indian constitutional law and many members of the Constituent Assembly appeared before the court. The chairperson of the drafting committee of the Constitution, Dr. B.R. Ambedkar, also appeared before the Supreme Court in 1952 in the celebrated State of Bihar versus Sri Kameshwar Singh. Ever since the Constitution was enacted, the Supreme Court has sat in Delhi. A lesser known fact is that the Supreme Court has functioned outside Delhi on 2 occasions, that is in Hyderabad in 1950 and in Kashmir in 1954. On the coming into force of the Constitution, all appeals of Privy Councils in Hyderabad and Kashmir were transferred to the Supreme Court. The appeal records of these courts were in local languages, and their translations would have entailed much expense and time. A far cry from AI-assisted machine translations today. Therefore, the Chief Justice decided to constitute a bench in Hyderabad and Kashmir to hear and decide the pending appeals. In 1954, a decision was taken to construct a separate building for the Supreme Court. The chief architect, Ganesh Bikaji Devralikar, designed the building in the shape of a balance with a pair of scales of justice. When you enter the court premises, you will find the pensive statue of Mahatma Gandhi facing the court building. The court's logo consists of the wheel of Dharma with the inscription Yato Dharmastato Jayaha, meaning where there is Dharma, there is victory. These are not merely ornamental imageries. They represent the values of the Constitution and the aspirations of our people. They serve as a reminder for both judges as well as lawyers to act righteously. The present Supreme Court complex was inaugurated by Dr. Rajendra Prasad on 4 August 1958. At the inauguration, Chief Justice S.R. Das presciently laid forth the responsibility of the court when he said, "To us, the new building stands forth as a solemn and sublime symbol of the majesty of the law. The portals of this palace of justice shall be open to every person who may seek redress for wrong, if any, done to them by their fellow citizens or by the state, and justice will be denied to none. The lowliest of the low, be he a citizen or a non-citizen, may as of right claim here equality before the law, and shall receive from this temple of justice equal protection of the laws. Later on, in July 2019, the additional building complex of the Supreme Court, where we are today celebrating this event, was inaugurated. The court's workload during the initial years was a fraction of what we witness today. In the annual report of 2005-2006, one of our former distinguished judges who is present here, Justice B.P. Singh, recounts that when he visited the Supreme Court for the first time in 1956, the proceedings were solemn and virtually dull. He also observed that at a time only 5 to 6 lawyers would be present in the court hall. Over the years, the workload of the Supreme Court has increased. Every day now, the Supreme Court has hundreds of cases on its docket. The judges of the Supreme Court and the staff of the registry put up tremendous work to ensure the speedy disposal of cases. Just to give you a simple sampling, in the last 3 months, 12,108 cases were filed before the Supreme Court. 12,471 cases have been disposed of. We have to also remember that the functioning of the Supreme Court was very different from the provincial high courts as they then existed. Many judges who are serving in the provincial high courts found it difficult to get accustomed to the new ways. When Justice Muhammad Hidayatullah was elevated to the Supreme Court in 1958, Mondays were miscellaneous days. Justice Hidayatullah's first day in court was a Monday. Late Sunday night, he found a huge bundle of 35 special leave petitions by his bedside. He was expected to have read them by the morning. However, Justice Vivian Bose, with whom Justice Hidayatullah was staying at the time, advised him to read only the later cases, because most of his colleagues would have only read the earlier cases, and that way he could control the conversation in the courtroom. Like Justice Hidayatullah, we, the bar and the bench, are also learning and adapting to the new norms on a daily basis. Over the years, the sanctioned strength of the court was increased, and currently it stands at 34 judges. As the number of cases increased, the court started sitting in smaller benches of 2, 3, and 5 judges. The Supreme Court's jurisprudential approach has been evolving. In the 1970s, the court adopted a broad, purposive, and contextual interpretation of the Constitution. In the past few years, the court has furthered the transformative vision of the Constitution by recognizing and protecting fundamental rights such as the right to privacy, decisional autonomy, and sexual and reproductive choices. Our court has emerged as a strong proponent of gender equality, whether it be in its interpretation of the laws of inheritance or securing the entry of women in the armed forces. The court has also ensured that the criminal justice administration is not delinked from the framework of human rights. For instance, while the death penalty has been upheld to be legal and constitutional, the Supreme Court laid down various mitigating and aggravating circumstances that a judge should take into account before awarding the sentence of death. This ensures fairness in the process. Procedural innovations, open court hearings in reviews arising out of death penalty cases, or psychiatric assessment of death row convicts have a humanizing influence on the law. Thus, the court has sought to use the language of the Constitution to humanize law and act as a protector and defender of fundamental rights and liberties. In the past few decades, India's legal landscape has undergone significant changes with the adoption of legislation such as the competition law and the insolvency and bankruptcy code. Consequently, commercial matters now comprise a significant part of the daily docket along with criminal matters. While dealing with such cases, the court has often drawn upon the new and emerging jurisprudence developed in other jurisdictions. To give you just one example, in dealing with the insolvency and bankruptcy matters, the court is often referred to principles enunciated by the Singapore courts because of a similarity in legislation. I did so in my decision in EBIC Singapore Private Limited versus Educom Solutions. In arbitration cases, the court has taken a conscious stand of upholding the sanctity of contracts. The Supreme Court has made a constant endeavor to ensure access to justice for everyone. The court has facilitated increased access to justice by diluting the requirement of local standi through public interest litigation in the 1980s, by which anyone can approach the constitutional courts in India to seek a redressal of a violation of their fundamental rights. By doing so, the court opened its door to persons bereft of the means to approach the court because of their social and economic disadvantage. This has provided a space for citizens to converse with the state on equal terms. In turn, the court has been using its jurisdiction to make the rule of law a daily reality for persons belonging to the marginalized communities. During the COVID-19 pandemic, the Supreme Court adopted innovative technological solutions to reach out to the people by adopting video conferencing of court proceedings. During the period between 23rd March 2020 and 31st October 2022, the Supreme Court alone heard 3.37 lakh cases through video conferencing. We updated our video conferencing infrastructure in courtrooms at a meta scale, and we are continuing to use such technological infrastructure to allow a hybrid mode of court hearings that allows parties to join court proceedings from any part of the world online. In the recent budget, the Government of India has announced a provision of rupees 7,000 crores for phase 3 of the e-courts project. This will help to enhance the accessibility of judicial institutions and improve the efficiency of the justice delivery system in India. Such endeavors will ensure that the court truly reaches out to every citizen of our country. If we peruse the history of this court, we realize that the history of the Supreme Court is a history of the daily life struggles of the Indian people. The mentioning list every morning in the Court of the Chief Justice of India spans anywhere between 60 to 100 cases. Through these seemingly innocuous requests, we can sense the pulse of the nation. Above all, we send a message in this uniquely citizen-centric initiative, and that message is of an assurance that this court exists to protect our citizens from injustice. Their liberties are as precious to us as to them, and that the judges work in close connect with our communities. In conclusion, then, let me say that there should be 3 principles which should guide our approach, and I borrow something from what has been delivered by the greats of the past who have decided cases before us. First is that we must apply the precautionary principle in the work which we do. Second, we as judges must apply the principle of sustainable development, because it is the principle of sustainable development which will ensure that the institutions which have been created to us will be safe and sound when we as pilgrims in this path hand over the baton to our successors. And third, we must always remember the public trust doctrine, because we hold this institution in trust for the future. So if we apply these 3 principles, the precautionary principle, the principle of sustainable development, and the public trust doctrine, not just in the context of environmental litigation, but each day of our lives, we will ensure that our court remains vibrant despite climate change. For the court, there are no big or small cases. Every matter is important, because it is in the seemingly small and routine matters involving the grievances of citizens that issues of constitutional and jurisprudential importance emerge. In attending to such grievances, the court performs a plain constitutional duty, a plain constitutional obligation, and a plain constitutional function. Before I conclude, I thank Chief Justice Sundaresh Menon from the bottom of my heart for unveiling this lecture series. As I said, we couldn't have had a more distinguished jurist across the world than him to deliver this inaugural lecture. Thank you, Namaskar.
Thank you, Your Lordship. On this special occasion, may I request the Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, to present a memento to the Chief Justice of the Supreme Court of Singapore, Honorable Mr. Justice Sundaresh Menon. Ladies and gentlemen, the Supreme Court of India is proud to announce an annual lecture series on the various facets of the role of the judiciary. May I now request the Honorable Mr. Justice Sundaresh Menon, Chief Justice, Supreme Court of Singapore, to present the inaugural lecture on this lecture series entitled The Role of the Judiciary in a Changing World.
The Honourable Justice, Dr. Justice D.Y. Chandrachud, Chief Justice of India, the Honourable Justices of the Supreme Court of India, the Honourable former Chief Justices and former Justices of the Supreme Court of India, the Honourable Shri Venkataramani, the Attorney General of India, distinguished guests, ladies and gentlemen. It is truly a great honour for me to be invited to address you as part of the first Supreme Court of India Day celebrations, commemorating the inauguration of this august institution on 28th January 1950. I thank the Honourable the Chief Justice for the invitation. I thank my friend Justice Kaul for his very generous introduction, and I thank the Supreme Court for the generous hospitality that has been extended to me and to my colleagues in connection with this visit, an especially delightful one coming as it does following 3 years of considerable disruption for all of us. The Supreme Court of India is among the busiest courts in the world, and its justices among the hardest working judges because of the immense caseload that they carry. I saw this myself when I was honored to observe proceedings yesterday in the Chief Justice's court alongside him. It is therefore a tremendous privilege for me to have spent several hours with the Chief Justice and a number of his colleagues, and I very deeply appreciate all that they have done to welcome me to India. Over the course of the last 73 years, when the Supreme Court has rendered justice according to the usages, the laws, and the Constitution of India, the world has changed immensely. But in many ways, the fundamental setup of our courts, whether here in India, in Singapore, or for that matter in most other places around the world, has largely remained the same. We are charged with the same constitutional responsibility to do justice, and we take a broadly similar oath of office to resolve controversies of all sorts according to law, without fear or favor, affection, or ill will. The rule of law, which is a fundamental pillar of our systems of government, depends on this. Yet it is an inescapable reality that changes are taking place in the world around us that are dramatic both in rate and in scope. This raises the question of how we should square our unchanging, unyielding judicial responsibility with the relentlessly dynamic world that we find ourselves in today. How should we envision the role of the judiciary in this changing world? That is the subject that Chief Justice Chandrachud has invited me to address, and this opens an extremely timely conversation, if I may say so. Today, I will propose a vision for a future-ready judiciary in 4 parts. First, I will briefly reiterate what is demanded of us in our judicial role. This will set the context for the subsequent discussion. I will then describe what I refer to as the perfect long storm facing judiciaries around the world. In the third part of my remarks, I will explain why we, judges, must respond urgently to this series of challenges precisely because of the effects of these changes on our ability to discharge our responsibility as judges. And finally, I will sketch out some ways in which the functioning of the judiciary could evolve to meet these challenges. Even though judiciaries may not be equipped or mandated to address some of the issues that the world is facing, my suggestion will be that we nonetheless can and must refine and modernize our vision and understanding of the judicial role if we are to remain able to administer justice effectively and to help maintain order and legitimacy in our societies. So let me begin by reiterating some basic notions of the judicial role. In Marbury and Madison, Chief Justice John Marshall famously declared that it was emphatically the province and duty of the judicial department to say what the law is. To those of us raised in a constitutional framework based on the separation of powers, this is foundational. Parliament makes the law and the executive branch carries it out. But the imperfections of human foresight, the limitations of language, the constraints of the Constitution, and the human tendency to try to get what one wants all come together to give rise to disputes over what the law is and therefore over whether one is acting lawfully. And when this happens, it is the courts that must decide. This, at its core, is our role, to resolve the many disputes that are part and parcel of societal life. Indeed, as Chief Justice Chandrachud recently observed, it is in the seemingly small and routine matters involving grievances of citizens that issues of moment, both in jurisprudential and consequential terms, emerge. When the judiciary functions well, it serves as a stabilizing force in society by easing tensions and giving final and authoritative directions to help all of us get through these numerous daily conflicts. When it functions well, the judiciary serves as part of the glue that holds the various moving parts together. To discharge this role, there are perhaps two core requirements. First, those appointed must have the competence and the capacity to discharge the responsibility that is cast upon them. And second, their status as the arbiters and umpires of society has to be accepted by the subjects of their decisions. As Alexander Hamilton famously noted, we hold neither the sword nor the purse, only judgment. Consequently, a judiciary needs legitimacy to function well, and this is secured when it enjoys the confidence of the public. Gaining that confidence is a function of many factors. Does the public generally believe that we are acting honestly and wisely, impartially, independently, and with integrity? Does it believe that we are competent to discharge our duties? Are we regarded as being out of touch and existing only to serve the needs of the wealthy and the powerful? Or does the public believe that we are here to serve justice and that we are resolute in our commitment to bring down whatever obstacles stand in the way? I ask you to keep these two requirements, competence and legitimacy, in mind as we turn to examine the challenges that judiciaries around the world now face. I speak to you in the aftermath of what might be described, perhaps with some optimism, as the aftermath of the COVID-19 pandemic. But it is striking that when future historians look back at this time, the pandemic might only be one amongst a number of world-changing events that have taken place over the past few years. This has been a time when we have witnessed dramatic shifts in the global political environment, with the outbreak of what might prove to be a long-drawn war in Europe. Lurking in the background are even graver threats, such as the prediction by the Intergovernmental Panel on Climate Change that we are at the precipice when it comes to climate change. Singapore's Senior Minister Tharman Shanmugaratnam recently suggested that the world faces a perfect long storm of global challenges. Alongside global geopolitical instability, global health security, and the climate change crisis, we see the threat of stagflation and the risk of growing economic and social inequality. He called this a perfect long storm because he considers these to be a confluence not of random shocks, but of structural issues and insecurities that will be with us in the long term. These global challenges concern us as judges because they will have an impact on one or both of those essential elements of our work, competence and legitimacy. They place greater demands on the level of competence and the kinds of competencies that judges will need in order to be able to do their work. And they add significantly to the pressures threatening to undermine the legitimacy of public institutions, including courts. I have identified 6 specific types of challenges, most of them arising directly or indirectly from these global challenges, which have particular relevance to courts and legal systems. They come together to form what we might think of as a perfect long storm bearing down specifically on justice systems around the world. The first 3 sets of challenges have a direct impact on the ability of judges to competently discharge their duty of adjudicating disputes. They revolve around the growing complexity of the disputes that will come before us. Let me elaborate upon them in turn. First, the global challenges that I described earlier on will give rise to new legal issues. Though these challenges might first and foremost be political problems, almost all of these problems will also have a legal dimension, which means that the responses to these challenges, whether in the form of executive action, legislation, or private initiatives, will sooner or later give rise to disputes that will end up before the courts. The climate crisis provides an obvious illustration of this, with environmental regulation, green financing, and corporate governance being just some examples of a wide gamut of potential legal issues in this area. And even inaction in the face of these global challenges is likely to give rise to litigation. In the area of climate change, there are prominent examples of private individuals and entities bringing governments to court for omitting to do enough to curb carbon emissions, with notable judgments having been issued in favor of such claimants by the highest courts in the Netherlands and Germany. If these global challenges are here to stay for the foreseeable future, then all judiciaries will have to be ready to deal with their fact patterns and legal implications. We can expect such disputes to be complex, demanding, and time-consuming. And to be equipped to cope with them, courts will have to be prepared to develop new legal concepts and tools, as well as new ways of deploying existing legal principles and practices. The second type of challenge is what I call the complexification of disputes. This refers to complexity that arises not from a specific subject matter or factual pattern, but rather to the growing complexity of disputes generally, stemming primarily from the rapid rate of advance in science and technology. There are 2 facets to this trend: growing technical complexity and growing evidential complexity. Technical complexity comes from the increasing amount of scientific and technological knowledge that adjudicators will need to grapple with. The world around us is being transformed by technology. Contracts are entered into using algorithms, and vehicles are learning to drive themselves, which means that familiar legal concepts premised on the actions of human agents can now give rise to uniquely complex legal issues. Advances in science can similarly transform ordinary questions, such as a person's state of mind, into potentially complex inquiries into fields such as psychiatry. So too has the evidential complexity of disputes exploded, because our reliance on electronic communications and systems and the massive amounts of data that they collect means that even a modest transaction can easily generate volumes of documentary evidence. The complexification of disputes gives rise to the very real possibility of cases that are so complex or voluminous that they strain the ability of any single human adjudicator to process. In one construction arbitration, for instance, the tribunal reportedly received written submissions extending to 10,000 pages. Applying an estimate of 6 minutes to read and digest each page, it would take an arbitrator 1,000 hours, or about 6 working months, to read the submissions, to say nothing of the time it would take her to evaluate them in the light of the rest of the material. But even more routine cases may prove significantly more demanding to try using conventional methods, thus increasing the cost of litigation and compromising the expeditious disposal of cases. That is aside from the personal toll that working on such cases takes on lawyers and adjudicators. As science and technology continue their inexorable advance, these challenges will only grow. We cannot rely solely on traditional case management tools to deal with the problem of complexification. Instead, judiciaries will have to consider new and potentially radical ways to contain and downsize disputes or face a real crisis of capacity. And a third set of challenges come from the fact that legal issues increasingly disregard jurisdictional boundaries. This is because we are becoming more economically interconnected than ever before. Despite the well-publicized phenomenon of countries around the world shutting their borders and turning inwards at the start of the pandemic in early 2020, by the end of that year, transnational trade had recovered to pre-pandemic levels and has continued to grow since then. The volume of international commercial disputes that have connections with multiple jurisdictions will therefore keep rising. But international commercial dispute resolution is by its nature decentralized. There is no single predetermined control center for each dispute. Instead, each court has the prerogative to rule on jurisdictional disputes in the proceedings brought before it, including questions of whether the dispute is better brought before another court or arbitral tribunal, or has already been decided in another forum. In addition, we are sure to encounter new legal issues in areas ranging from cryptocurrency to environmental, social, and governance regulation and litigation, all of which rarely heed jurisdictional boundaries. The case for convergence or harmonization in many of these areas is obvious. If different jurisdictions applied their own idiosyncratic standards in deciding challenges against arbitral awards or the legal status of new types of assets, for instance, this would greatly increase the cost of compliance and transnational dispute settlement, and therefore stymie cross-border trade. This is why in areas like arbitration and mediation, the international community of states has come together to ratify treaties or to develop model laws. But even then, different courts do not always apply these instruments in a uniform way. The short point is that judges will increasingly need to be sensitive to developments in the laws of other jurisdictions in order to properly decide disputes. And beyond this, they will also increasingly need to actively cooperate with foreign counterparts in disputes that need effective concurrent cross-border management, such as the growing field of complex cross-border insolvencies. But courts have traditionally had neither the inclination nor the avenues to communicate and collaborate across jurisdictions. This is something that I suggest we all will need to work on, and I will come back to this point a little later. I turn to the next three sets of challenges which will directly affect the legitimacy of the courts. These two stem ultimately from global challenges such as rising wealth inequality, the risk of stagflation, and political instability, which we can expect to lead to a steady growth in disaffection and polarization in our societies. A recent report by Oxfam noted that the richest 1% captured nearly 2/3 of all the new wealth generated since the start of the pandemic. Some commentators argue that this extreme disparity in wealth is being created not through innovation or production, but rather through the exploitation of workers and consumers. Whether or not the charge of capitalist access is true, what should most immediately concern us as judges is the reality that if the unequal accumulation of wealth continues to sharpen, we can expect grave challenges in securing access to justice for those left behind, who will feel increasingly marginalized and disillusioned with the justice system. Sharp economic polarization in societies inevitably contributes to the polarization of public discourse, and this too is accompanied by a phenomenon which might be called truth decay. Together, they sow the seeds of a series of challenges that threaten to seriously undermine the legitimacy of justice systems around the world, and it is to these I now turn. I begin with the challenges surrounding access to justice, which is being impeded not only by growing inequality, but also by the increasing complexity and cost of dispute settlement and pressures on the resourcing of justice systems and of legal aid. One manifestation of this trend is the steady increase in the number of self-represented litigants who navigate our justice systems. But this belies a much larger phenomenon of people with legal needs that never see the light of day. A study by the World Justice Project suggests that there are 1.4 billion people globally who are unable to obtain justice for civil legal problems such as property, matrimonial, or employment disputes. I have suggested elsewhere that the difficulties faced by potential litigants seeking to access justice consist of three facets: a physical gap, which comes from distance or other physical difficulties in accessing the courts; a resource gap, which comes from the financial and other costs of navigating a justice system; and a literacy gap, which comes from a lack of appreciation that certain problems are legal problems that come with legal solutions. Together, they constitute a justice gap, and its existence is a pressing concern because nothing is more corrosive to public trust in our justice systems than the perception that those systems are the preserve of a privileged few and priced out of the reach of ordinary people. A large part of the literacy gap comes from not knowing how to access the courts. A significant contributor to this is the folklore that often surrounds the law and the public consciousness, and which gives entirely incorrect impressions of how it operates. And it is becoming harder than ever to correct such misconceptions because of the next set of challenges: truth decay. This refers to the proliferation of disinformation and the devaluation of truth in our societies, which attacks the justice system in at least two specific ways. First, truth is the foundation upon which courts do their work. As Justice Stephen Gagler of the High Court of Australia has observed, the rule of law depends on our courts making factual findings that are reliable, because justice according to law requires applying the law to the true facts. And while there does not appear to have been empirical studies on this, a number of recent examples suggest that truth decay is spreading into court proceedings. In Singapore, our courts have seen a rise in partisan and unreasoned expert opinions, especially, for instance, in psychiatric evidence adduced in criminal cases. And truth decay can also be seen in the conduct of some advocates who have in some cases attempted to conceal facts from the courts or to delay proceedings on spurious grounds. Second, it is essential that the findings of the court are generally accepted in the public sphere as generally reflecting the truth. If that is not the case, then our rulings become merely another voice in an endless clamor of opinions on the merits of disputes. This is exacerbated when baseless allegations are made against judges, suggesting that their rulings merely reflect their personal agendas. Perhaps the most notorious example of this is the Daily Mail headline in the United Kingdom, branding judges in the Miller case as enemies of the people, implying that they had sought to thwart the public's desire to leave the European Union. More recently, when the majority opinion of the US Supreme Court in the Dobbs case was leaked, a New York Times article purported to fact-check passages in the draft opinion that recounted the policy arguments made by the petitioners. The subtext seemed to be that the author of the draft opinion had distorted the truth in order to find for the petitioners and advance an agenda. As a result of its creep into our courtrooms, truth decay diminishes the standing of judgments and of courts. And this ultimately undermines the stabilizing work of the courts in upholding the rule of law and maintaining order in society. And this brings me to the final set of challenges, which is in many ways the culmination of all of the foregoing challenges. And this is the increasingly evident breakdown of trust in public institutions as a whole. The 2022 Edelman Trust Barometer found that distrust was now society's default emotion. In many democratic societies, less than half the people surveyed said they trusted institutions such as the government and the media. This may well be due to causes such as truth decay, but it is also likely to be due to the sense that public institutions are failing to deliver on their mission. We should not think that courts can stand apart from other institutions when it comes to this deficit of trust. The potential breakdown of trust in the courts is arguably the most critical of all the challenges that we face, because the legitimacy of the judiciary rests upon a broad public acceptance that we are reliable truth seekers and truth finders seeking to do justice according to the law. If this trust falls away, then the courts are left to operate solely by the force of state power, and the belief in and respect for the rule of law in our societies will collapse. I therefore suggest that judiciaries are facing the onset of a number of discrete challenges which strike at either or both of the core requirements for the discharge of our judicial duties, namely competence and legitimacy. These challenges come together to form a perfect long storm for the judiciary in the same way that Senior Minister Tharman has described those facing the world at large. They are a confluence of lasting threats, not random blips. And they give rise to a matter of serious public concern because the judiciary plays a crucial role in underwriting the legitimacy of our social, economic, and political institutions by ensuring that their activities abide by the law and that the law remains relevant under changing circumstances. It is therefore apt to characterize the challenges facing the judiciary as a perfect storm because they threaten the rule of law and ultimately of our institutions as a whole. The question might nonetheless be asked, should judiciaries be the ones to respond? After all, problems like truth decay and climate change are political problems, surely, in need of political solutions. To my mind, the answer is obvious, but the concern is worth addressing because it stems from a number of long-standing strictures that have traditionally defined and limited the judicial role. It has been said that judges traditionally held themselves aloof from the public. Thus, there are principles warning judges against commenting on government policy, defending their judgments publicly, or engaging with the media. And furthermore, the courts only act within the limit of their understanding of their proper constitutional role in line with the separation of powers. Even though the principles underlying these limitations, those of judicial independence and separation of powers, are well justified, they do not mean the judiciary should remain completely aloof. They do not go so far, and the strictest of these prohibitions have long fallen out of fashion. Thus, while judges generally continue to let their judgments speak for themselves, most judiciaries no longer see anything wrong with other facets of public engagement that spread awareness of judicial work. For instance, the Chief Justice of Canada holds an annual press conference discussing the work of the court, while members of the UK Supreme Court have given television interviews discussing their approach to work and their home life. These shifts in judicial attitudes reflect an evolution and refinement of our understanding of the judicial mission. And I suggest there are three aspects of this evolving vision of the judicial role that explains why we as judges must respond as best we can to the perfect long storm. First, and most importantly, beyond sitting as referees over disputes, our true mission is the fair and efficient administration of justice so as to uphold the rule of law. To look at this mission from a purely adjudicative or process-based view is to miss a much larger picture, which is that the administration of justice takes place within a system. And what an individual judge does when presiding over an individual case is only one part of how the system as a whole delivers justice. It is the effectiveness of the system as a whole that determines whether access to justice is available, whether judges are equipped with adequate expertise and tools, and whether public confidence in the judiciary is secured. We should, therefore, adopt a systemic perspective of the judicial role, in which the judiciary evolves from seeing itself as a collection of discrete adjudicators to becoming an institution that excels in the administration of justice. Second, by unpacking the perfect long storm into its constituent parts, we see that the challenges looming on the horizon are not just a morass of political entanglements for the other branches of government to resolve. Even though we in the judiciary cannot address many of their root causes, these challenges each have legal and operational dimensions that directly or indirectly impact the judiciary. As a result, these matters will enter our domain, and we're duty-bound to mount a response. And third, as the primary operators of the justice system, judges are best placed to act, albeit within the applicable constraints. From our own perspective as judges, we should also recognize the value in being active participants rather than mere passengers in the transformation of our justice systems. And because change is often resisted when it is imposed from the outside, by far the best way of achieving and maintaining the changes that need to be made to our justice system is by having judges actively participate in the process. So once we look at our judicial role from these perspectives, I suggest we will see that impartiality in the courtroom whilst fundamental, is no longer synonymous with inaction in the face of the perfect long storm. On the contrary, we must act urgently and decisively to mount a sufficiently robust response to these challenges, while drawing up a refined set of boundaries for the judicial role. I therefore turn to the final question of how we should go about this Herculean task. First, I think it is crucial that we take a systematic approach. Many of these challenges appear so vast and foreboding, with root causes that are beyond our competence, that we risk losing steam or going off track if we respond in a piecemeal or reactionary way. We must develop a clear vision of the evolving role of the judiciary so that we refocus our efforts around what we can do to become institutions that excel in the administration of justice. When we look at it in this way, I suggest for a start, there are three key themes that should shape our vision of the judicial role. First, building a user-centric court system. Second, enhancing judicial competencies. And third, picking up a point that Justice Call made, promoting international judicial engagement. Let me elaborate on each of these in turn. The first theme concerns the importance of putting ourselves in the shoes of the public, who are our users and our constituents. Ultimately, the justice system does not exist to serve the convenience of judges and lawyers. Instead, we should adopt a user-centric approach to its design. Building a user-centric court system is an important way for us to secure public trust and legitimacy. There are two facets of the judicial role that I suggest should evolve in order to achieve this. First, courts should take seriously their assistive responsibility towards their users. I'll develop that in a minute. And second, we should regard public communications and outreach as one of our core functions. Let me take these in turn. First, we should recognize that even as courts must remain impartial, they also have an assistive responsibility towards court users, and in particular, litigants in person. Such self-represented litigants are a fact of life for judiciaries around the world today. And they face significant barriers that impede their ability to access justice because legal systems and court processes have traditionally been designed with judges and lawyers in mind rather than with lay users in mind. And that is simply not fit for purpose when the system is now accessed by so many litigants in person. To help bring down these barriers, the court should draw a distinction between impermissible legal advice on the one hand and the provision of legal information and practical assistance on the other, and not shy away from the latter. One way the courts can achieve this at scale is by publishing guides and information packs with lay users in mind. This is an approach that our courts in Singapore have embraced. For instance, our state courts have published the guidebook for accused in person, which sets out in considerable detail what accused persons can expect at each stage of criminal proceedings and how they might prepare themselves. Our family justice courts have published the Family Orders Guide, for instance, which helps self-represented litigants cope with the alien task of drawing up draft orders of court. The Singapore courts maintain a single website which provides self-help procedural guides for civil, family, and criminal proceedings. We can also discharge our assistive responsibility to lay court users by making court processes easier to understand and navigate by doing away with legal jargon and simplifying our procedures. We should especially pay attention to the vast potential of technology to help discharge our assistive responsibility. Assistance which in the past had to be provided face-to-face by court staff and volunteers can be scaled up without limit and at relatively little cost if we find the right digital tools. Such tools can provide practical assistance to court users. For example, the divorce e-service created by our family justice courts guides self-represented family litigants through the entire process of preparing and filing divorce papers. Digital tools can even provide legal information previously available only by consulting a professional. We developed, together with the Academy of Law, the Motor Accidents Claims Online, an online tool that was launched to enable potential litigants to get a free preliminary assessment of the likely allocation of fault and award of damages. There is immense future and further potential for such digital tools to radically change the way justice can be accessed in the most commonly encountered kinds of disputes. Second, it is important for judiciaries to see public communications and outreach as an essential part of their role. Studies have shown that public knowledge about courts is closely linked to public trust in judicial institutions. The courts should therefore take up the task of spreading awareness of their work. I've already mentioned the annual press conferences held by the Chief Justice of Canada as a prime example of such proactive outreach, and there are other examples. The Singapore Supreme Court publishes case summaries of significant decisions on our website and on social media, and we compile annual reports setting out the judiciary's key work. We also collaborate with other stakeholders, such as law schools, to further our outreach efforts. But outreach does not only involve delivering our messages to the public. User centricity requires us to continuously be sensitive to what our users are saying, to be open to feedback from our users. We therefore conduct regular user surveys to understand the shortcomings of our court systems and processes so that these can be improved. These are just some of the ways in which we can narrow the justice gap, combat disinformation, and maintain public trust. I turn to my second theme, which is enhancing judicial competencies. I suggest we will have to raise the capabilities of our judiciaries if we are to keep up with the underlying drivers of complexification, to reduce barriers to accessing the courts, and to be prepared to face the new legal issues that are upon us. This is key to enable us to sustain our legitimacy because it'll give the public confidence that we can discharge our responsibilities. I suggest this should translate into a renewed emphasis on two facets of the judicial role. First, we should invest significantly in continuing judicial education and training. And second, we should continuously pursue innovation in the justice system. Turning to the first point, judiciaries must take responsibility for the education, training, and development of those in their ranks. The historical view that judges required no training and somehow emerged fully formed at the moment of their appointment has long been discarded. Instead, we now accept that continual training and upskilling are a necessary part of a judicial career. This is not least because of the new challenges that are emerging in the perfect long storm, which places new demands on judges in terms of legal knowledge, scientific and technical understanding, effective case management, and even awareness of other legal systems. These programs will increasingly need to incorporate a significant element of interdisciplinarity. In Singapore, we established the Singapore Judicial College to deliver judge-led judicial education and training, and have been continuously upgrading its capabilities in order to equip our judges to meet these demands. And for these initiatives to work, judges themselves must fully embrace the need for lifelong learning. And besides our judges, we also need to develop our court administrators to excel, innovate, and lead, because they do much of the work of running our courts and interfacing with our court users. But enhancing judicial competencies on an individual level will not be enough. We need to raise the floor for legal practice as a whole and improve the functioning of the litigation process at a systemic level. This requires the judiciary to become innovators within the justice system so that we can employ best practices and explore new and promising solutions. In the Singapore courts, we've pursued a number of priorities in procedural reform, of which I will touch on just two. The first is to improve access to justice by streamlining procedures and deterring inefficient litigation practices. Following a multi-year study led by one of my colleagues, Justice Tay Yong Kwang, we rewrote our civil procedure rules. The new Rules of Court 2021 are governed by 5 overarching ideals, stated clearly at the beginning of the rules: fair access to justice, expeditious proceedings, cost-effective and proportionate processes, the efficient use of court resources, and fair and practical results suited to the needs of the parties. These ideals animate the management of cases by judges. And to achieve this, a high degree of flexibility is built into the rules with active judge-led case management at its core. Our second priority that I want to touch on is to develop and promote practices and tools that will help contain and downsize complex disputes. So, to help contain disputes, the new rules of court empower our courts to order the parties to attempt mediation. And to downsize exceptionally complex disputes, we introduced an optional protocol that the parties can agree to in the Technology, Infrastructure and Construction list of the International Commercial Court, which can streamline the adjudication of complex disputes comprising dozens or even hundreds of related claims. And to sustain these improvements, we will need to keep them constantly under review and keep our minds open to other new and promising practices, as the Chief Justice observed in his remarks. We will have to continuously consider what further skills or challenges we need to enable us to meet the emerging changes. And this is just part and parcel of taking charge of our own development and improvement so as to retain our competence to discharge our responsibilities. The third and final theme is promoting international judicial engagement. Gone are the days, I suggest, when judiciaries could operate in jurisdictional silos, unconcerned with legal systems and courts beyond their shores. Instead, it is both necessary and highly beneficial today for judiciaries to engage with their counterparts from other jurisdictions. And let me tell you that in just one day, I learned so much from the interactions that I had, both with the Supreme Court, the Delhi High Court, and indeed with the technology office of this court. I suggest that this new aspect of the judicial role again has two facets that cut across the goals of improving competence and securing legitimacy. First, engaging in judicial diplomacy. Second, supporting the development of a transnational system of justice. By judicial diplomacy, I refer to formal and informal communication and collaboration between courts in different jurisdictions. Informal cooperation between judiciaries has become relatively widespread in recent years, with the Conference of Chief Justices of Asia and the Pacific, the Judicial Seminar on Commercial Litigation, and the Judicial Roundtable on Commercial Law being just a few examples of such meetings that my colleagues and I, and indeed colleagues from the Supreme Court of India, actively participate in. These gatherings allow us to pool our collective experience in order to help us address the legal issues that are proving to be prevalent across jurisdictions. That is one of the reasons why I regard the invitation to address you today as so very special. Formal cooperation between judiciaries, once practically unheard of, has also gained traction. The Supreme Court of Singapore, for instance, has entered into memoranda of understanding with a number of foreign courts in order to allow each court to refer questions of foreign law to its counterpart in the foreign jurisdiction, greatly simplifying the task of ascertaining a complicated point of foreign law. We also helped develop and have adopted the Judicial Insolvency Network guidelines to enable court-to-court communications for the management of complex cross-border insolvency cases, which is an extremely important case management tool in these cases. Perhaps the high watermark of international judicial exchange is the modern-day phenomenon of traveling judges. These are jurists who travel from their home jurisdiction to serve on a court in a different jurisdiction. Courts that have traveling judges in their ranks, such as my court, the Singapore International Commercial Court, are able in this way to assemble a particularly deep bench of eminent jurists from around the world and to benefit from their deep experience and the exchanges that this affords us. One of your erstwhile colleagues, Justice Arjun Sikri, now graces our bench as an international judge, and he makes an extremely valuable contribution to the court that goes well beyond the work of hearing cases. But reaching further than an international network of judges and courts, I suggest we should work towards an even more ambitious goal: the proactive development of the transnational system of justice. On a number of recent occasions, I've argued in favor of recognizing the existence of this system and working to develop it further in the area of commercial law. And I've suggested that we can see this by viewing the many discrete players and processes that regulate transnational commerce today as though they were part of a system rather than as a mere compilation of rules. In practice, we achieve this by promoting the convergence of substantive and procedural laws wherever possible. And this will have the undoubted benefit of reducing the uncertainty and costs involved in transnational commercial activity. Within a transnational system of justice, courts around the world can work in dialogue with each other as we develop and promote the legal norms that we will need in order to address the perfect long storm, including norms in areas such as climate change, jurisdictional conflicts, and natural justice. This would help us to strengthen the international rule of law, thus helping to facilitate and sustain the open flow of goods and services across borders and enhancing the ability of institutions around the world to respond to the global challenges that we face. The irreversible effects of globalization have made us all participants on the transnational plane, and judiciaries therefore should not underestimate the importance of the transnational element of their work. Instead, we should refine our vision of the judicial role to encompass international engagement, and this would make us more effective and at the same time promote public trust. Chief Justice, ladies and gentlemen, I offer these three themes as a base for developing a blueprint for how judiciaries can shore up their competence and legitimacy in the face of the perfect storm that is looming. First, redoubling our efforts to build a user-centric court system by recognizing that courts have an assistive responsibility towards court users and by engaging in public communications and outreach. Second, working tirelessly to enhance judicial competencies by investing in judicial education and training and pursuing continuous innovation in the justice system. And third, actively promoting international judicial engagement by engaging in judicial diplomacy with our counterparts across the world and contributing towards the development of a transnational system of justice. Finally, we should see that cutting across this revitalized vision of the judicial role is a need for strong leadership. To develop the kind of systemic approach that is called for, we need judicial leaders to develop an overarching vision and set the tone. And this should not be seen as the exclusive preserve of the heads of judiciaries. Judges and indeed court administrators at all levels need to be leaders within their own domains in order to drive and sustain change at the scale. At the start of my address, I painted a rather bleak picture of the perfect long storm approaching judiciaries around the world. We face global changes, the complexification of disputes, the challenges arising from greater interconnectedness amongst jurisdictions, rising barriers against access to justice, truth decay inside and outside the courtroom, and an impending breakdown of trust in public institutions. Meeting these challenges will require a multipolar effort. And while the courts cannot lead the charge against their root causes, by refining our understanding of our role as judges, we can tap upon the strength and expertise of judicial institutions and redirect them towards responses to these challenges that accord with the constitutional role of the judiciary. We should aim to become institutions that excel in the administration of justice in the ways I have suggested. This is a critical mission. If we fail, the perfect long storm portends a breakdown of the rule of law. But if judiciaries are successful in this endeavor, they will help guide their societies through the tempest. I thank you very much for your attention.
Thank you, Your Lordship. This is indeed an auspicious beginning to the new lecture series of the Supreme Court of India. May I now invite Honorable Mr. Justice K.M. Joseph, Judge, Supreme Court of India, to give the vote of thanks.
Justice Sundaresh Menon, Honorable the Chief Justice of Supreme Court of Singapore, Dr. Dhananjaya V. Chandrachud, Honorable the Chief Justice of India, my esteemed brothers, Justice Sanjay Kishan Kaul and Justice Ajay Rastogi, my esteemed sisters and brother judges of the Supreme Court of India, former Chief Justice of India and judges of the Supreme Court of India, the Attorney General, the Solicitor General, the Additional Solicitor Generals, Chairperson and members of the Law Commission, judges of the High Court of Delhi, President and members of the Supreme Court Bar Association, and Supreme Court Advocates and Recording Association, senior advocates, Chairman Bar Council of India, members of registry, law clerks, and members of the media, ladies and gentlemen. A vote of thanks brings up the rear, and when the curtains are rung down, but my task is pleasant, as I must offer words of gratitude. It was G.K. Chesterton who said, I would maintain that thanks are the highest form of thought, and that gratitude is happiness doubled by wonder. We are both overjoyed and wonderstruck at the quality of the deliberations we have witnessed. Chief Justice Sundaresh Menon was born to Indian parents in 1962 in Singapore, just 3 years before Singapore became independent. At the age of nearly 4 years, he speaks of an incident which perhaps has shaped his life and his views about Singapore. Strolling down a street in Singapore with his mother, a thief took away some ornaments worn by his mother. He narrates in an interview that even in Singapore of the 1960s, on the third day, the jewels were recovered and the policeman rang the bell and appeared with the stolen items. At the heart of this incident is the uncompromising commitment to the rule of law Singapore is justly famous for. Chief Justice Menon wanted to become a pilot. However, on account of the fact that he had to wear spectacles from a young age, it was not to be. Since the age of 12, he wanted to become a lawyer for some reason. He puts it down to the inner desire to help others. He followed upon his dream, and not only did he become a highly successful lawyer, but also he went on to become the captain of the Judiciary in Singapore, and not just a pilot of a plane. He became the Attorney General at the age of 48 and the Chief Justice of the Supreme Court of Singapore at the age of 50. Chief Justice Menon not only brings the highest levels of scholarship to his task, but a great deal of compassion. Chief Justice Menon is a strong supporter of the concept of convergence, which is an effort at removing divergence in cross-border jurisprudence. He is an ardent supporter of bringing judges up to date through a rigorous regimen of judicial education. Finding time out of his busy schedule as Chief Justice, he has been an ardent supporter of bringing about a transformation in legal education as well. He appears to be extremely tech-savvy and is keen on harnessing its benefits for the benefit of litigants. He is very optimistic in particular about the role which artificial intelligence will finally come to play in the administration of justice. Chief Justice Menon, your thought-provoking and masterly lecture, which has left the audience spellbound, will continue to haunt all of us for a long time to come. More particularly, I'm sure it will provide a huge inspiration for the young law clerks who are present in full strength. On behalf of all present, I thank you from the bottom of my heart. Chief Justice Chandrachud has been putting in an incredible amount of time and energy, in particular, ever since he has assumed the onerous and august office of the Chief Justice of India. He is full of transformative ideas, and the planning and the conduct of this function, down to its smallest detail, is largely due to his efforts. I thank you on behalf of all present here. I express my gratitude to my esteemed brother, Justice Sanjay Kishan Kaul and Ajay Rastogi. Last but not the least, I express a deep sense of gratitude to all those present here, without whose presence this function would not have been the resounding success which I believe it has been. Thank you, Jai Hind.
Thank you so much, Your Lordship. We'd like to thank the audience also, and I request you all to join us for lunch.